أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. سبحانك لا علم لنا إلا ما علمتنا إنك أنت الحليم الحكيم. Good day everyone, especially to our instructor Ma'am Siti Farisha Dataya Magapisa. So our topic for today is about the legal status and rights of children. But first, I want to say that I am not that good in this subject, which is the Islamic personal law, but I'll do my best to deliver my report. So let's continue. Legal status and rights of children. Okay. So Islamic marital jurisprudence, legal status, or the legal relationship. Um, in the definition, Islamic law or Shariah, marriage, nikah, is a legal and social contract between two individuals. Marriage is an act of Islam and is strongly recommended. So, under Sharia law, Islamic law, we can determine the legal status or the legal relationship of two individuals, which is the couple, through marriage or nikah, or with a social contract between two individuals, which is the husband and the wife. So, marriage is an act of Islam and is strongly recommended, which is marriage was being said in Hadith is the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam. So, polygamy is permitted in Islam under some conditions, but polyandry is forbidden. I am not that sure with the pronunciation, but I'll just read it as polyandry. Just correct me if I'm wrong, ma'am. Far, and thank you for that. Okay, so polygamy is permitted in Islam, which means that a Muslim man is allowed to marry more than one wife, up to four wives. That is permitted in Islam under some certain certain conditions. Whereas in the opposite, polyandry is forbidden or denounced by Islam, which means that the Muslim wife is not allowed to marry more than one husband. Only the husband is allowed in Islam to marry more than one wife, up to four wives, but not in the case of the wife. So that's it. Legal status or relationship can be determined through marriage or a social contract between two individuals. Legitimate children. So, how can we say that a child is legitimate? So, first, we have two. Number one, children conceived in lawful wedlock shall be presumed to be legitimate. Whoever claims illegitimacy or impugns such filiation must prove his allegation. So first, we can determine that a child is illegitimate children or child of the husband and wife. Of course, the husband when um, so we can determine that a child is illegitimate child of the husband when the child is conceived in a lawful wedlock. That means that the child was born whereas her parents were lawfully um, got married in public, or at least they had their wedding ceremony. So whoever claims illegitimacy or impulse of the child, then such filiation must prove his allegation. So that's the first thing. We can determine the legitimacy of the child when it is under when the parents is under nikah, or I mean that they went into nikah, or that means that there is a nikah happened to the two individuals. Number two, we can determine that the child is illegitimate child when the children born after 6 months following the consummation of marriage or within 2 years after the dissolution of the marriage shall be presumed to be legitimate. As we can remember, we already tackled this last sem. Ma'am Far have told us that we can determine the legitimacy of the child if the child was born 6 months after the consummation of marriage. So, when the two individuals got married and the wife delivered the baby 6 months after the marriage, then the child is a legitimate child of the husband. So, against this presumption, no evidence shall be permitted other than that of the physical impossibility of access between the parents at or about the time of the conception of the child. Why are we returning? I think I am just pressing the wrong direction. Okay, so legitimate children. So under Article 60, children of subsequent marriage. Should the marriage be dissolved and the wife contracts another marriage after the expiration of her iddah, the child born within 6 months from the dissolution of the prior marriage shall be presumed to have been conceived during the former marriage, and if born after the latter. This means that under subsequent marriage, the is child was owned by the former husband when the wife delivered the baby within 6 months from the dissolution of the prior marriage. So we know that the subsequent marriage means when a wife contracted another marriage after her prior marriage. So after the dissolution of her prior marriage, the wife delivered a baby. Then uh, when it in when it no then the wife when the wife delivered the baby within 6 months after the dissolution of the prior marriage, then the child was conceived during the former marriage. That means that the child was owned by the former husband of the wife, and if born after during the latter, or and if the child was born after 6 months, not within 6 months but after 6 months, then the child is a legitimate child of the current husband and not the former husband. Okay, so let's differentiate it again. We have within 6 months and we have after 6 months, whereas the wife contracted a subsequent marriage. So when the wife contracted a subsequent marriage or got married to his second husband, then we can determine that the child or the baby that the wife gave birth to was owned or was a child by the former or the previous husband when it was delivered within 6 months. But when after 6 months, then the child was under or was conceived during the um uh or I mean that the child was owned by the second husband. Like that. Periods of presumption of legitimacy. So under the Muslim law, the presumption of legitimacy of a child is based on the following periods to state. So these are the presumptions of periods of presumptions of legitimacy of the child. So first, A child born within 6 months of the marriage is not attributable to the husband and is therefore illegitimate. So, subhanallah, the child who was born within 6 months after the um, consummation of marriage or after 6 months of the marriage, then the child was an illegitimate child of the husband unless the mother's husband acknowledges that the child as his. So, within 6 months of the marriage, the child was born, then therefore it is illegitimate child of the husband unless the mother declared that the child the was the child of the husband. So if a child's mother had a previous marriage which was dissolved and immediately following the dissolution she contracted a subsequent marriage, the child shall be presumed to have been conceived of the previous marriage. So the same with the previous one which I explained. If for example the if for example the wife gave birth to a child within 6 months after the dissolution of the marriage, after the dissolution from her previous marriage, then she contracted a subsequent marriage, then the child belongs to the former husband, which is conceived during the former husband conceived during the former husband, yes. But if after 6 months, then the child was owned or belonged to the current husband. Number two, number two of periods of presumptions of legitimacy. A child born after 6 months of the marriage is presumed legitimate unless proven otherwise. So paulit-ulit lang gud siya. So a child born after 6 months, then the child is proven legitimate and belongs to the father unless proven otherwise, or there are other or yeah, unless proven otherwise, or there are some other reasons that could declare that the child was not owned by the by the husband. So after 6 months of the marriage, the child is legitimate unless proven otherwise. Okay, so number three, a child born within 2 years following the dissolution of the marriage is presumed legitimate. So this means that when a child, for example, the mother and father um, got divorced, and then the mother delivered a child within 2 years, within 2 years following the dissolution of marriage, then the child is um, a legitimate child of the husband unless proven that there was impossibility of access between the mother and the alleged father at or about the time of the conception of the child, such as when it is proved that the husband is impotent. So, unless proven that there are no any uh, there was impossibility or of access between the mother and the alleged father. This means that uh, um, the child who was born within 2 years after the dissolution of the marriage, from dissolution of the marriage, then the child was illegitimate um, uh, daughter or son of the father unless the father is impotent or uh, which is not able to give birth to a woman, and or there is no any possible access for them to um, do something to produce or to create a baby. So, or that the spouse were living separately and access was not possible, or that the husband was suffering from serious illness that rendered sexual intercourse between them impossible. So, um, after the dissolution of marriage, then the wife gave birth to a child within 2 years. Then automatically the child was belonged to the former husband, or yeah, belong to the former husband, unless the husband is impotent or there were no any possible access for them to do something to create the baby, or unless the husband is um uh uh unless the husband had this serious illness that could render or that could render the sexual intercourse between them. Number 4, a child born after 2 years following the dissolution of the marriage. Take note, number 3 is a child born within 2 years. In number 4, a child born after 2 years following the dissolution of the marriage. The paternity doesn't get established from the woman's husband of the dissolved marriage in case the dissolution is occasioned by the husband's death. Okay, so in this scenario, the child was born after 2 years following the dissolution of the marriage. Then there were no paternity relationship to the from the child to um the father, unless that occasionally in the case where the husband is dead. So only that. If the reason was not death, then the child was not belong to the former husband, even if was not belong to the former husband after being born 2 years after 2 years following the dissolution of the marriage. And in the same manner, when it is by reason of divorce, except in the latter case when the husband acknowledges the child as his. Okay, so other than the reason of death, the child was belong to the husband if the husband acknowledges that the child is his. For the reason of divorce. Number 5, a child born within 6 months following the dissolution of a prior marriage. A child born within 6 months following the dissolution of a prior marriage and during the subsequent marriage of the mother shall be presumed to have been conceived during the former marriage or a legitimate child of the former marriage. I've said this already. Yun nga, paulit-ulit lang siya. Then, let's repeat it because it's there on the fact sheet. So, number 5, and it is under the periods of presumption of legitimacy of the child. So, number 5, within 6 months following the dissolution of a prior marriage, for example, they separated, they were divorced, then the wife gave birth to a child within 6 months, then the child is belonged to the former marriage or former husband of the wife. This means that the child was conceived during the former marriage of the two individuals. So the child was illegitimate child of the former husband if born within 6 months. But take note in here, we said that no, that's it. Number 6, a child born after 6 months. Okay, so this is the another periods of presumption. So number six, a child born after 6 months, because what we've said in number five is within 6 months. So in number six, a child was born. A child born after 6 months following the dissolution of a prior marriage and during the subsequent marriage of the mother shall be presumed to have been conceived during the latter marriage or illegitimate child of the latter marriage. So, if after 6 months following the dissolution of a prior marriage, then the mother or the wife contracted a subsequent marriage to the second uh, to his to the second marriage, then the child is a legitimate child uh, of the current husband of the wife. So, if the child was born within 6 months, then this is under the subsequent marriage. When the child was born within 6 months, then the child was illegitimate son or daughter of the previous husband. But if after 6 months the child was born, then it is belong to the current husband. So Article 62, rights of legitimate child. So what are the rights of legitimate child? So we have three in here. A legitimate child shall have the right to, first, or letter A, is to bear the surnames of the father and of the mother. That's the first thing. Um, let's give the detail after this survey because there is a still following slides that which gives detail to the rights of the legitimate child. Letter B, to receive support from the father or in his default from his heirs in accordance with Article 65 and 68. And letter C, to share in the legitimate furud and other successional rights which this code recognizes in his favors. So Article 62, rights of legitimate child. Source of article is Quran verse 233 on support A semicolon A, not A but Q. Q verse Q, which means Quran, verse 11 and 12 on inheritance. And the Code Commission, Civil Code, Article 364 on use of surname, custom ADA. So, child's right to use of parents' surnames. The child in Islam had an inalienable right to legitimacy. It adopts what may be termed of the principle of legitimacy, which in the summary of Rose-Coser holds that every child has a father and one father only. This means that the child in Islam has an automatic right of legitimacy to the parents. Under Rule 7, Administrative Order Number 1, Series of 2005 of the National Statistics Office of OCRG, the first name of the father or the surname of either the father or the mother may be used as the child's last name subject to Islamic or Muslim law or Aada or customary laws. So, under the administrative order, the child can use the surname of either the father or the mother as his her last name, subjected to Islamic or Muslim law. Aray. The customary practice among Muslims in Muslim countries regarding the use of surname, is to use the name of the father as the surname and from the father to the grandfather within the direct paternal line. So, for example, A, the son of B, open close parenthesis B, the son of C. Thus, Abu Bakr bin Bakr bin Qasim. So, no, not Abu Bakr, but Abdul bin Bakr bin Qasim. So Abdul is the name, bin Bakr is the name of the father, and then bin Qasim is the name of the grandfather of Abdul. So commonly in Muslim countries, they used the name of the father, then the name of the grandfather as the surname of the child. So for example, in my case, my name is Mushira Rahman Pagayawan. So if I use the name which is commonly used in Muslim countries, then since my father's name is Basir, then my grandfather's name is Daoud, then it could be that my name is Mushira bint Basir bint Daoud, like that, which is actually known in our case because most of us in Islamic education is an ustad and ustada. So in the present provision, paragraph A allows the child. This is in the present provision. Letter A allows the child to use the surname of the father and of the mother. This is patterned after the American system whereby a person uses as his surname his father's surname and the mother's surname as his middle name. Okay, so this is the most common and which we followed even today as a Filipino. Uh, we had our name, then after our name, we use the surname of our father to be our surname. For example, Mushira is my name. Pagayawan is the surname of my father. Then I use that surname of my father as my surname. Then the surname of my mother become the middle name of mine. So Mushira Rahman Pagayawan, like that. So that is pattern from the American system. It is believed that since the use of surname is a person's right, either of the two ways can be adopted, since there is no restriction on this right other than the requirements of good faith. So either of the two in the American pattern from the American system, we can use any of the two, the the way of Muslim countries or the way of the American system, because we are given the right. So that are the rights of the legitimate child. Child's right to inheritance. Likewise, as a legal consequence of a valid marriage, the children born to the spouses are their legal heirs, and in the event of the death of either of them, their children are entitled to inherit from the property left by them. They are among the compulsory heirs who are never excluded from the inheritance of their parents unless disinherited for cause provided. So, this is the most important thing that everyone has to understand under the right of the children to the inheritance of or the child's right to inheritance. So, um, the legal consequence of the valid marriage is where the child who was born legitimate has the right or which is entitled to inherit from the property of their parents. So if for example suddenly the parents were dead, the father was died for example, then child the legitimate child has automatic right which is entitled to the property left by his her father or parents, unless proven there were uh, other reasons that may cause for the child not to be entitled to the property of his her parents. So that's it. So that's all for today. Thank you so much for listening. I hope you learned something. I actually did my best to deliver the report because I am not that good in this subject, which is the Islamic personal law. Uh, thank you so much. I hope we're all doing good. May Allah keep us safe at all time and give us more knowledge that which is beneficial for us from the dunya until akhirah. سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت نستغفرك ونتوب إليه السلام عليكم ورحمة الله وبركاته. Good night because it's already 1 o'clock in the morning.